Welcome back to the courtroom, guys. Today, we are stepping into the ring with the undisputed queen of legal reality TV, Judge Judy. We have a classic landlord-tenant dispute, but as you know, nothing in Judge Judy's courtroom is ever simple. The plaintiffs, a mother-daughter duo Chima and Asa, are suing their former landlord for the return of a $2,000 security deposit. But right out of the gate, something smells fishy. The lease was signed by both the mother and the daughter, implying they both live there. However, the landlord suspects that the mother was never actually a tenant and simply co-signed to help her daughter get the apartment. That might not sound like a big deal, but in contract law, lying to a judge about who is occupying a property is a credibility killer. Judge Judy is going to use her signature rapid-fire questioning to establish the baseline facts. Watch closely how the mother reacts when asked simple questions about her living situation. Her body language and hesitation are about to give away the entire game before the trial even hits the 1-minute mark. Is this a case of a bad landlord keeping money or entitled tenants trying to pull a fast one? Let's find out.
Mr. LaJoie, what kind of property did you rent to the plaintiff?
It was a condo.
2 bedrooms?
Yes.
Who signed the lease?
Sima and Asia Johnson.
Your first name is?
Sima.
And this is your daughter?
Yes.
Did you sign the lease on the apartment because both you and your daughter intended to live there?
Yes, Your Honor.
Did both your daughter and you live there?
Yes.
Full time?
Yes.
Don't roll your eyes and don't say anything that is going to come back at you later. You know, do you understand? It's going to be a problem.
Okay.
Do you understand?
I do.
You don't want to make a problem.
No.
Okay. Now, did you live there full time?
Yes.
Did your daughter live there full time?
Yes.
From when to when?
It was April 2013 to May 2014.
And what's the address?
I don't know it off the top of my head. Would you like me to read it?
No, the address of where you were living for a year. No, don't look
okay.
there. No. Don't look there.
Okay.
How old are you?
45.
A 45-year-old woman knows the address of where she lived for a year. You got my drift?
Yes.
Address.
Don't remember.
Stand up next to your mother.
There it is, the moment the case falls apart. This is one of Judge Judy's most famous lie detection techniques. She asks a question that any truthful person could answer instantly. What was your address? If you live somewhere for an entire year, full-time, that address is burned into your memory. You don't need to look at a piece of paper, and you certainly don't need to look at your daughter for help. By failing this simple test, the mother has destroyed her credibility. Judge Judy now knows she is lying about living there. Why does this matter? Because if the mother wasn't living there, but signed a lease saying she would, she has committed fraud on the contract. Furthermore, if she wasn't there, she can't testify to the condition of the apartment or who else was living there. She has effectively removed herself as a useful witness in her own lawsuit.
Now, what you want is your security deposit back.
Correct.
You moved out in May. On what date in May?
I believe it was the 14th.
Not believe. What date in May?
The 14th of May.
Do you have your lease?
Yes.
I'd like to take a look at it. Okay, so let's get to the point where defendant says that you really weren't living there on a full-time basis, but other people were in and out. Is that right?
Correct.
You have any witnesses to that?
I do, actually.
How are you related to this case?
I live below his unit.
How long have you lived there?
I've lived there for 16 years.
How many tenants has Mr. LaJoie had in that unit?
Up until now,
Yeah.
2.
The 2 of them and one other person?
Well, no, prior to them moving in, no tenants.
There were no tenants.
No, he lived there directly.
Any problems with him?
No, ma'am.
Enter the star witness. In landlord-tenant disputes, third-party witnesses are worth their weight in gold. This gentleman lives directly below the unit in question. Unlike the landlord, who isn't there 24/7, or the tenants, who have a financial incentive to lie, the neighbor sees everything. Notice how specific his testimony is. He states he has lived there for 16 years. This establishes him as a permanent fixture in the building, someone who knows the rhythm of the property. When he says he has never seen the mother, that is the nail in the coffin for her earlier testimony. The plaintiffs likely didn't expect the landlord to bring a neighbor to court. This is a classic ambush of truth. The mother's claim of living there full-time has just been objectively disproven by a credible, independent source.
Now, how often did you see Miss Johnson?
I have never seen her at the unit.
Never.
Never.
Maybe that's because he works most nights.
I didn't ask you anything.
Okay.
How many times did you see her daughter?
Every day.
Did you ever see anyone else in the house?
Yes, her boyfriend.
Did you see him there up until May?
Yes.
What's his name? Last name?
Latrell.
Anybody else?
Yeah, it was in November, December that another female moved into the unit as well.
Name?
Fisher.
How long did she stay?
She would come down and visit.
How long did she stay?
She stayed initially for 3 weeks,
And?
then went back up to her mother's,
And?
and then she came back for an additional 3 weeks.
So she was there for 6 weeks?
Yes.
This is where the tennis case goes from bad to worse. Are now dealing with unauthorized occupants? Almost every standard residential lease has a clause limiting who can live in the unit. Usually, guests can stay for a few days or maybe a week, but 6 weeks, that establishes residency. The neighbor has identified 2 people, the boyfriend, Latrell, and a friend, Fisher, who were living there off the lease. This is a material breach of contract. Unauthorized tenants create liability issues for the landlord. If Latrell starts a fire or Fisher gets hurt, the insurance might not cover it because they aren't on the lease. By allowing these people to move in, the daughter violated the terms of her agreement. This gives the landlord potential grounds to keep the deposit for damages or breach of lease, depending on state law.
Latrell,
He would take care of my dog while I was at work, because it was a condo.
did he ever sleep over?
Yes, about.
Just a second.
Yes.
Just answer my question.
Yes.
So he would sleep over.
Yes.
And I assume that when he slept over with you.
Well, most relationships, I guess, would do that.
You got where I'm going?
Yes.
Oof. That attitude is a fatal error. The daughter Asia tries to get snarky with Judge Judy. Most relationships would do that. She is trying to normalize the boyfriend sleeping over to deflect from the fact that he was essentially living there. But you never, ever give Judge Judy attitude. By answering sarcastically, she is signaling that she doesn't respect the court or the contract. Judge Judy's response: "You already understand that I don't believe a word you said is the judicial equivalent of a knockout punch. The judge has determined that both plaintiffs are liars. The mom lied about living there, and the daughter is lying about the boyfriend's residency status. Once a judge decides you are a liar, you typically lose, regardless of the other facts."
Good. So you already understand, Miss Johnson, that I don't believe a word that you said to me before. You do understand that.
I understand what you're saying, yes.
I'm glad you understand what I'm saying. So you moved out in May, and according to your lease, the lease started on the 14th of the month, which means it terminated the 14th of March, 2014. But then they stayed on as month-to-month tenants, correct?
Correct.
Which means that if the next month's rent was due on March 14th, did they pay that rent? March to April.
Yes, they paid it on April 1st for the month of April.
So then they started to pay on the 1st of the month.
Yes.
Did they pay on the 1st of May?
No.
How much did they pay on the 1st of April?
$16.95. And when they gave me their 30-day notice, they asked if their portion of May could be taken out of the deposit.
Okay. With whom did you have that conversation?
Both Sima and Asia.
Where did that conversation take place?
At my current residence when they handed me the notice.
Did you have that conversation with him?
Yes.
And did he agree?
Yes.
Yes.
Okay. And how much was their deposit?
$1,500.
That's not true.
How much was your deposit?
2,000.
You have proof of that?
We
Yep.
have the check.
I'd
There
like
was
to
a
see it.
$500 per the lease, $500 non-refundable pet deposit.
Is that correct? Did you have a pet?
I did have a
We
pet.
did have a pet.
So that was a non-refundable pet deposit, so that means that your deposit was $1,500.
My assumption is...
Not your assumption.
Okay.
Is that what it says here? It was a non-refundable pet deposit.
Here is the final dispute. The pet deposit versus the pet fee. The tenant believes she put down $2,000 total refundable money, but the lease says $500 was a non-refundable pet deposit. Legally, words matter. If a contract says non-refundable, that is a fee, not a deposit. It is the price you pay for the privilege of having an animal in the unit. It is not money you get back just because the dog didn't chew the baseboards. The tenant's assumption, Michi gets that $500 back, shows she didn't read or understand the contract she signed. Judge Judy is strictly enforcing the four corners of the document. You can't assume your way out of a written contract. Another case closed with a harsh lesson in contract law and credibility. The plaintiffs tried to double-team the landlord, but their story fell apart under the slightest pressure. The mother lied about living in the unit, the daughter moved in unauthorized tenants, and neither of them understood that a non-refundable pet fee means exactly that. You don't get a refund. Judge Judy sided with the evidence and the independent witness, proving once again that you cannot lie your way to a payday in her courtroom. If you enjoyed this breakdown, Make sure to smash that like button. Comment down below. Would you have let the boyfriend move in? And don't forget to subscribe for more high-drama courtroom analysis. See you next time.